What do you think? Yeah. What's going to be the impact of that? Thanks.
Right, I think we're about ready to dive in. Welcome, everybody. Good morning. Today is Friday, May 16th, 2025. It's 11:52 a.m. We're on the record today from 11:50 to 12:50, and we're here to discuss AO 2025-61, an ordinance amending Anchorage Municipal Code, sections 8.20.030 and 8.20.035 to improve the public safety and reduce wildfire danger by establishing criminal penalties for unauthorized fires. We'll start with the introductions. Mr. Johnson.
Zach Johnson.
Yarrow Silvers.
Aaron Baldwin Day.
Cameron Perez Verdia.
Anna Brawley.
We have Christopher Constant here on the phone. We have Mr. Myers.
Yes, thanks, Chair.
Hello, welcome, Mr. Rivera.
Present.
Thank you. Anyone else on the phone? On the
Hey, this
assembly?
is Jared Gerker. I'm on the phone as well.
Thanks, Mr. Gerker. And we have from the administration,
Eva Gardner, Municipal Attorney.
Dennis Wheeler, Municipal Prosecutor.
Thea Agnew-Benben, Mayor's Office.
Doug Schrage, Anchorage Fire Chief.
All right, so we have a presentation today, and we'll go ahead and start with the municipal attorney. Welcome.
Hello. I plan to give a brief legal overview of what this ordinance is, what it does, how it relates to other laws, and then we'll open it up for questions. We have Dennis Wheeler, Municipal Prosecutor, Thea Agnew-Benben from the Mayor's Office, and Chief Schrage here as well to answer questions about enforcement and what that will look like if it becomes law. So AO 2025-61 expands, in a nutshell, expands criminal liability for unsafe fires. And there are a few goals here. Ultimate goal is, right, reduce fire danger, improve public safety, really deter people, make them think twice before they build unsafe fires, give law enforcement meaningful tools to go after people when they do create unsafe fires. And it also tries to focus on the highest risk seasons and locations. And so on a more technical level, it actually creates new misdemeanor crimes for certain types of fires. Specifically during fire season, which by state statute is set from April to August, so the season when we are at the highest risk of wildfire, it would criminalize any fire built on somebody else's property without permission. That would include private property as well as public property. It would criminalize building any fire that violates a burn ban when the fire chief has issued a burn ban. And it would also year-round criminalize any fire on public streets and sidewalks. It also clarifies that any fire that's in violation of a burn ban is dangerous and needs to be controlled and reported. And that builds on existing code provisions. So currently, we have a pretty broad range of fires that municipal code deems unsafe. And that is all over our civil code. And then there's a very much smaller subset of fires that our code says, well, it's a misdemeanor, it's an actual crime. And so this AO, this ordinance, is designed to start kind of bridge that gap, not fully, but expand the criminal liability to not make such a big gap between what our code says is inappropriate with only civil penalties and what actually has enforcement teeth behind it. So this next slide is a few of the areas in civil code where we prohibit fires. There's kind of a general prohibition on open fires with certain exceptions for ceremonial, religious, cooking fires. There's a general prohibition on open fires in parks, and also general prohibition on the use of wildfire in wildfire danger areas. And those have a lot more detail in them, but that's just an example of the broad range of fires that code deems unsafe. Currently, we only have 2 crimes that relate to fire. Those are in Title 8 of the Municipal Code, which is where you'll find all of our misdemeanors. The first is criminally negligent burning, which applies to fire that causes actual property damage. So if you build a fire, it damages someone's property, you can be charged. If you build a fire, it does not damage someone's property, you cannot be charged. And there's another one, failure to control or report a dangerous fire, which says if you are, around or a fire that is dangerously out of control, that is threatening life or a substantial amount of property, and you don't control it when you have a responsibility to do so, or you don't report it, then you can be liable. under the criminal law. That's all we have right now. And what these have in common is that they're kind of after the fact, right? After the fire has already gotten out of control, after the fire has already caused damage, then we have enforcement tools that have real teeth in them. But they don't do anything really ahead of the time to deter people from initiating unsafe fires in the first place. So there are some laws that are similar to what we're proposing here. One of them is something that the Anchorage Assembly actually did in 2022. It was an emergency order, EO 2022-2, and it temporarily expanded fire misdemeanors to include any violation of a burn ban. It made it temporarily, I think, for a 60 or 90-day period in the summer of 2022, a crime.
Just a quick clarification. It's an emergency ordinance.
Emergency ordinance, sorry. And there are, so that termed out hasn't been brought back. Several cases were charged under that at the time that it was in effect. And there are Alaska statutes that make it a misdemeanor to set fires on forested land or to inflammable material on somebody else's property, or make it a misdemeanor to violate a state-issued burn ban. And those exist right now. They're fairly, in the section of the statutes that applies to forested land, so not directly applicable to all the circumstances we're seeking to cover here. And that is my overview. Any questions?
Mr. Johnson, Ms. Burley.
Yeah, thanks. So first off, let me say I'm really glad you guys are doing this, and just kind of being out and talking to people in the public about this. There's been a lot of enthusiasm, so I appreciate it. My question though, starting kind of at the very beginning, right? So if we go to the top of page 2, where you're laying out, no starting fires without consent, and then we say during fire season. I guess my question would be, if we're talking about unauthorized fires, like places where you should not be creating a fire, does the seasonality really matter? I understand the risk is greater during the summer, but why not just say you're not supposed to start a fire there? It's illegal. It doesn't matter the time of year.
Yeah, it's a great question. And I think, right, the goal of this is when you're putting criminal penalties, and this comes with up to a year in jail, it comes with, I think, up to $10,000 in fines. When you're putting that serious, like criminalizing conduct, then the goal is really to focus on the most dangerous conduct. So somebody who builds a fire, in January when it's 20 below, maybe in violation of our civil code, right? We already have things that say it's unsafe. We have some enforcement tools. Does that really need to be something that lands them in jail if it isn't actually at that time endangering the life and property of other people? And so this really is to target those high risk areas that have the potential to really create significant harm. And so for that reason, it's, burn bans and fire season.
Okay, thank you.
All right, Anna.
Yeah, I have a few kind of specific questions. I guess I'll run through them right now. I have 3. Does property include things that aren't buildings? Because I know, we think of because my understanding of arson, I've learned recently, is related to a structure versus, setting trees on fire, for example. But property I know means land and the stuff on the land. That's one question. Second question, how does this interact with use of things like grills, burn barrels? Because I know we kind of contemplate the idea that a fire can be contained, but how would that work? And I guess the question would be, how does that work within a burn ban, outside of a burn ban? Because I don't think we're trying to criminalize things like burn barrels. And then third question, how does this interact? I guess this is a general question with criminal code. How does it interact with minors? So I'm picturing the scenario, every summer Linary Park has an issue with people going out on the beach next to the coastal trail, building bonfires on the beach. And that is an issue really when it is a dry season. If that is a 17-year-old who is in high school, what happens to them? Those are my 3 questions.
Thanks. So the first question, does this apply to land? Yes, this would apply to, real property, not just buildings. I think we wouldn't need this if it only applied to buildings, because we already have a code provision that says if you damage property, like of another, which I think if you build a fire in a building, you're already there. But yes, it would apply on land. Second, how it would apply to grills. I mean, I think that if it's a contained fire, that's safe, but taking a step back from the type of fire mechanism, you shouldn't really be grilling on somebody else's property without permission anyway. Our parks have designated areas for grilling. They have designated areas for fire pits. And so the purpose of this really is during fire season, you should not be building a fire anywhere that isn't appropriate to build it unless you have permission from the landowner, which can come in the form of, the municipality providing grills and barbecue pits. But yeah, so it would kind of be pretty broad and apply to all fires. And then third, minors and bonfires. I think that is a question on the kind of enforcement, prosecution, sentencing end in terms of how juveniles would be treated when faced with this type of charge. But I think that if we want to enforce our laws, we do have to enforce them uniformly. And so it wouldn't have an exemption for teenagers building fires. Hopefully we could do a public education campaign to make sure people understand the consequences of what they're doing, but it would apply.
Okay, yeah, and just, so it sounds like the key thing here is an unauthorized fire. So it's not so much the type of fire, it's where it is and whether they're allowed to do it and other conditions. And then, yeah, I'll just say, I guess, I understand the need for this. I just want to register a concern about who this will get enforced against and to make sure that it actually is consistent, because I think the history of law enforcement is that, some folks get, for various reasons, get punished more heavily than others. And so I think that seems to be a risk with this, regardless of what the code says, but thank you.
Cameron?
Yeah, thank you. Just a few questions. Just in terms of definitions and the usefulness of this, to light, build, use, or maintain, I'm wondering both the purpose and value of distinguishing those things, and as it relates to this. And I mean, I think to myself, when we do these, they become enforced in a very literal way. And I just want to understand why that is. To light, build, use, or maintain, it feels to me that it could be interpreted in different ways. So that's the one question. Second question is, and this is more of a philosophical question, I guess, is the value of increasing penalties as it relates to deterrent. And I guess I'd just like to hear your thoughts on that, about whether that works or not in your experience. Yeah, those are probably the two first questions, and I have a couple others, but let's start with those two.
Sure, thank you. So first on the definitions, light, build, use, or maintain. One other aspect of this that I didn't highlight in my original presentation is accountability. This is seeking to hold people accountable when they are, creating or causing or maintaining, perpetuating dangerous fires. That is something that should come with accountability to Anchorage, the people of Anchorage, neighborhoods, and other residents. So there is no, I think, necessarily.
So if I built it, but I didn't like, if I that's what I'm trying to get to is that, what I mean, if I didn't do anything about it, but I'm maintaining it, right? If I use it, why would that be a penalty if I use it?
Looking at the next code section, there is already an existing duty, right? If there is a dangerous fire and you don't report it, we already do put duties on people with criminal penalties for failing to report, or control dangerous fires. And so this is stepping it up and saying during fire season, these are all, in certain contexts, these are all dangerous fires and you should not be participating in and perpetuating.
No role related to it. Like whether you light it or build it or maintain it or use it, all of those are the same.
If you are providing support to that fire, then this would hold you accountable.
Okay. I just want to, I'm thinking about someone walking past it and, and whether they're still at the same level of fault as somebody who built it and lit it, and that sort of thing. So trying to understand that.
And on your second philosophical question, I think there are entire bodies of, studies and analyses and statistics on the value of penalties relative to deterrence. And I think Thea from the mayor's office may be able to speak more to this, but I know that there is an interest in enforcement and in holding people accountable. And if you don't have any penalty, if you don't have anything at the end of your efforts to deter people from engaging behavior, then it is very hard to affect change. And I will say, Mr. Wheeler can speak to this as well, but within prosecution, when somebody is charged with a crime, they have expanded access to therapeutic courts. And so I'm not saying prosecution is, a cure for everything, but there are avenues within our existing prosecution system to connect people with therapeutic courts and wellness courts in ways to help them address their issues and work through things in a way that isn't just strict criminal sentencing, you get thrown in jail. So I think that with that expanded view of what prosecution actually means, paired with the need for some consequence for activities that are objectively dangerous, then it makes sense here.
Just a quick follow-up. That just leads me to this. Yeah, the intent, right? If the intent is to do harm or the intent is to survive, right? And so when we go to the prosecution, how does that play into it? If we were to prosecute somebody in this, you using this, and what's the difference between someone who did it for a malicious reason versus did it to stay warm? What are your thoughts about that?
I think one of the policy considerations already built into this code is the idea that the staying warm piece is addressed by dealing with this during fire season, right? So there's some built-in assumption that the weather is warm enough that the fire isn't as necessary as it might be in January. So that's sort of built into this particular draft. In terms of their intent, whether it's malicious or not, we don't focus on their intent in that sense. It's really the intent around the fire itself. Did you negligently, recklessly, or intentionally create the fire circumstance? It's not the why. Were you doing it to cook? Were you doing it to be warm? That's not our issue. We don't distinguish between those, because then we're making judgment calls about that might concern the assembly. Are we dealing with people that are homeless and they get an exception versus somebody who maybe is clearing property for their next build? And so we try to avoid that kind of distinction.
I have one more follow-up on that, which is just that the starting premise of this ordinance is that fire in these circumstances is dangerous and poses a risk to the people of Anchorage. And I think that kind of need to accept that in order to move forward with it. And under that framework, then, yeah, somebody for convenience, right, for them, for their own purposes, does not have the right to jeopardize neighbors, residents, and other people in Anchorage just to, for their own individual needs. And there are other pathways to help.
So I have myself in the queue. The chief of police walked in right when we were discussing therapeutic courts and other forms of what I would call diversion. And so I think that that conversation is emerging right now in the muni, and this would be a tool that would be within the quiver to help people move towards alternatives to sentencing if they were under this. I think reasonable assumption. Thea's nodding her head yes. And to the risk of selective enforcement, I agree. And all of our laws suffer from the same flaw because we're people. You raised the Linary Park bonfire situation, and it's an interesting thing. I have friends that go out way out on the mud and burn things. And in some ways this criminalizes them. And I'm not sure that that's the best, but of course that's a limited circumstance. And I think we have to contemplate on the scale of relative harms when we're looking at a city that might burn down from the hill to the ground. It's definitely something we have to weigh. So, yeah, I guess I don't really have a question. I just have a lot there in the thought space. Aaron and then Zach.
Yeah, thank you all so much for being here. I'm curious about
Aaron, one sec. I just note that Mr. McCormick arrived just now at 12:11. Go ahead.
Yeah, I'm curious about the range of possible consequences for a Class A misdemeanor. Like what is that scope? And I heard up to a $10,000 fine, up to a year in jail, the possibility of therapeutic courts, diversion, that sort of thing. So I'm curious about what that could look like. And then I think I also have I'd love to be walked through sort of what would the process be? Let's say a neighbor notices a fire on public lands, and they call 911 to report the fire. What happens next, and who responds, and how, and then how do the folks who are responsible for that fire in whatever fashion, like how are they functionally held accountable in any case, right? Regardless of what the range of the consequences might be, how are they then held accountable to those consequences?
So with respect to the misdemeanor penalties, you're looking at up to a year in jail, and the fines may include a separate designation for restitution if there is property damage. So we would work with the affected property owner and ask for appropriate restitution, which we're required to prove up to the court. And the court can order that restitution on top of any fines or jail time. If you think about what we normally do in terms of the other cases we handle, it's very, very rare that someone is going to get that full sentence of a year. For example, our first-time OUI offenders are typically getting 3 days in jail. So the jail time for these cases would, of course, depend on somebody's criminal history and the circumstances, but I wouldn't expect significant jail time in these cases. And the second question, sorry.
Yeah, so so sort of walk me through the process, right, of what happens after a neighbor calls 911. I'm curious
Yeah.
about the mechanics and how this becomes enforceable.
Sure.
Do you? I mean, I'm imagining that a fire department response versus a police response. Are we writing citations? Are we immediately putting people in handcuffs and taking them somewhere? I mean, what is
Yeah.
the thing that happens next?
So the timing as between the fire department and the police department, those two gentlemen to my right speak to that, but I'll tell you that if there's an investigation, that's an APD investigation, they would then make a decision as to whether to charge. They would send that to us. We would review and then exercise our discretion as to whether to charge and if we're going to make an offer to the defendant, what that offer would look like.
Sure. So a follow-up question to that. How, in the case of, I'm imagining that this will be something that is very frequently a neighbor calling about a fire that is happening in an encampment or something like that. I'm curious about how you functionally find and then, yeah, I'm curious about how this actually becomes enforceable when it comes to folks who don't have a physical address or a way for us to contact them in a meaningful way.
Sure. I can just speak to the prosecution perspective and let these guys weigh in. But, basically that call goes in, it's processed however they process it. If APD is part of that response, they're going to have to make a decision as to whether they can gather enough evidence. For example, if the neighbor calls it in but can't identify anybody, or if those people aren't around, police can't identify them, then they have no one to charge, right?
Sure.
So that's kind of the basics of like any investigation. If they can identify the perpetrators and present to us a case that we think we can prove beyond a reasonable doubt, then we have the ability to go forward. And I'll defer to these guys. Thank you.
Okay, sure. Thank you, Member Baldwin Day. So the fire department will be dispatched to a reported fire and we'll put it out. If we have reason to think that the fire would be suspicious, then we would notify through dispatch the police department. And that would be, for the most part, the end of our involvement.
Okay.
Like Mr. Wheeler mentioned, there's challenges with any of the laws trying to figure out who's involved, who was there, who actually started the fire, who could have put out the fire. Generally, when the fire department shows up and starts putting out fires, everyone doesn't stick around and wait, and then it's also not the fire department's responsibility to grab everyone and hold on to them until we get there. So it's hard to prevent that from happening. We have already started working with dispatch. So when these types of fires are called, we know about it because it comes through our 911 system first to send officers at the same time. And so that we have a better chance of investigating the actual crimes. When we do get there and it is determined that somebody is going to be arrested for an offense like this, generally what's going to happen is they're going to be cited and released for this level of misdemeanor crime. And there's some occasions where that won't be the case. For example, if somebody that set the fire or didn't put the fire out, or whichever portion of this code that we're going to be charged with, if they're intoxicated, we have the ability, based on the bail schedule right now, to physically arrest those folks and take them to jail until they're sober. So that kind of addresses a little bit of the identification and how we can get a hold of it. It doesn't solve the problem, but it's a little bit better than a cite and release option. If they are not intoxicated, the bail schedule will not allow us to do a physical arrest on this particular, and that's a court system. That is not a ordinance issue.
Thank you.
Zach?
Yeah, thank you. Excuse me. And it's question related, I think, also to the enforceability piece of this. And it was asked, why do we not necessarily distinguish between light, building, using, or maintaining a fire? And I kind of have a theory here, but I'd like to check with, the prosecutors and the law enforcement whether it makes sense. I could imagine when somebody calls in a fire, an AFD and APD show up and you see 3 or 4 people around the fire, it may be very hard to figure out who actually lit it, right? I can easily imagine everyone saying, well, it was just here and then I came upon it, right? I was not the one who lit the fire. Well, I could imagine perhaps it would be nice to hold the person who started it more accountable. It might make it very hard if that's the threshold to actually bring forward a case that could relate to or result in somebody being charged. But I wanted to check to see if that's a valid theory.
Through the chair, you're exactly right. I can give you an example. There was a case recently within the past few months where a woman was next to a fire on a sidewalk downtown, maybe on 3rd Avenue, and a person calling it in took a cell phone video of that, but there was no video evidence of the person starting the fire. She just took advantage of the fire that was there, which is not a crime, but it could be under this provision.
Okay, thank you.
All right, Anna?
Yeah, thanks. I guess first I'll clarify, I definitely don't support folks starting bonfires down at the coastal trail. I brought it up because, and I know you weren't saying that either, but I think it is a good example though where people, do that and then we kind of benignly look away and the neighbors get upset about it. So, but it's just something to think about in terms of what that looks like in a dry season. My question is, I was just thinking back to, I guess maybe just this would be unpacking the idea of knowingly or negligently. And I'm thinking of, for example, we've had several apartment fires. Those can start for a variety of reasons. I'm also thinking back to our former police chief. I remember her going around talking to folks during holiday season, right, where a lot of home fires start because people are drinking and cooking essentially, because it's the holidays and then you're not watching the stove and things catch on fire. So I'm wondering, in especially multi-unit housing where it's not the landowner, maybe somebody is doing some kind of thing on the stove that's, I don't know, like I'm just trying to picture a situation where a fire starts. Certainly it wasn't the person's intent to burn the building down, and then it does burn down. Where is kind of the fuzzy line with negligently there? Because what I wouldn't want to see, because I imagine not all those folks get criminally charged if they drop a cigarette and their bed catches on fire, right? There's a lot of scenarios where someone is careless. They are not intending to cause harm, but they do cause that harm. So where does this ordinance fit into that kind of set of scenarios?
Sure. Yeah. And so if you look at the language of the ordinance, I'm looking at kind of the top of page 2. So it's the 820.030A2. It talks about if you need the consent of the person or entity having authority to grant consent. So if you are a renter in an apartment, you have authority to ignite fires in your own apartment. If you have a guest who says, hey, is it okay if I smoke in here? And you say yes, that's consent. So it's not strictly tied to ownership of the actual real property. It's tied to people who have authority to grant consent. So if you are a guest in a hotel room, right, you have control over that hotel room, I think, but that might be a little different, but it's not, it wouldn't sweep in people, having cooking fires in their apartment buildings.
Just a quick follow-up though. I know a number of places have essentially no smoking policies or no tobacco use policies. So that's an instance where the property owner has not given consent for someone to light a cigarette on their property. I guess I'm just trying to look at the edges of this to make sure that we're not prosecuting people for things that I think we generally treat as it shouldn't have happened, but they were not criminally acting as a criminal when a fire occurs in an apartment.
And to respond to that, that is already covered in here. We're actually not expanding that. So if you look at 820.030A1, which is the existing language, it is already unlawful to negligently damage the property of another by fire or explosion. So we already have that in code, so we're not making a change or expanding that category or that that context liability.
Mr. Wheeler.
Thank you. Through the chair, I'd also add that when we talk about like a stovetop cooking fire or a cigarette, there is a difference between being negligent generally and being criminally negligent. So there is a definite distinction there as well to keep in mind. We wouldn't charge pure simple negligence as a crime, but if they're criminally negligent, we theoretically could, not in the apartment circumstances, but under this code, there is a distinction between those two effects.
So I have myself in the queue and then I'll put Aaron next. So I have a little note here and then someone just sent me a note that's almost exactly what my little note says. Before I started in public service, I served on a grand jury, and in the grand jury, there was a meth lab being operated on a piece of property in a tent. And there was no enforcement and nothing happened. And eventually a property inspector found the meth lab and then the police got involved. So on the question of enforcement, people generally believe right now that it doesn't matter what the laws say, nothing's going to change. It doesn't matter because, currently it's illegal to camp. Camps are everywhere. Currently, all of these things. And so the real question is, like, if we have meth labs operating in park spaces and they're not being interdicted, why is this going to make a difference? And so that's kind of a philosophical question. Maybe it's a kind of a hardball or a softball, depends on how you look at it. But really, why is this going to make a difference?
This is Thea Agnew-Benben from the mayor's office. I think that's a big question. And I think what the mayor has said clearly since the beginning of her term and even in the last couple of weeks, very clearly, is that we have to kind of regain a better kind of sense of control over our public spaces and the conditions in our community. And I think one thing we hear very frequently and completely rationally is there's a huge concern about wildfire, and especially because we've seen these things happen in other places. And I think, to the largest degree, I believe we have a system that does try to treat people fairly, not pursue them, for criminal charges if there isn't grounds for that. And I think some of those pieces haven't been working that great. We sat here last week and heard from our prosecutor that we let 500 cases get dismissed last year. And in the last 3 months, we've dismissed 10. That's a massive change. So I think there's some basics that we have not kept up with over the last few years. And what I see the mayor doing and directing all of us to do is get those basics back in place. And I think our first step is to get the basics back in place. And then we'll see what has to happen after that. And so I think that's where we're at. And I think this is a really important piece for the season of the year where the danger is highest, where all of us have to say, yeah, I'm not going to be putting that fire on the beach. I'll do that in October when it's wet and gross outside. And if my kid's doing it, I can say, hey, guess what? That's like a year in jail. So, does it ever really be a deterrent? I can tell you what isn't a deterrent, not having any consequences. I think we're seeing that right now. So I think we need to start bringing some consequences back and see if that helps. And I think we have to have faith that the people that are in charge of these organizations aren't going to abuse that power.
Yeah, my question wasn't on the abuse side. It was on the will we do it at all side. That's the fundamental first question. So Chief Shruggy.
Yes, thank you, Chair. I'd like to add another deterring effect would be for the homeowner who burns their grass or brush or trees or garbage in their yard in a way that allows it to either escape or in violation of our standing burn bans that we issue regularly. So I think this will be a useful tool in that regard.
Eva?
Yeah, I just wanted to follow up on Thea's comments and just emphasize that you need all pieces of the criminal justice system to work in order for the system to work at all. So you need the officers out there enforcing, right? Bringing people in, referring charges. You need prosecutors who can pick up those charges and push them through to court. And you need a court that isn't so backlogged that it, has years old cases that aren't moving through the system. And I think everybody probably knows from, the news that all of those things have not been working very well over the last few years. APD has had a lot of vacancies, which is turning around with 1 and 2 full academies coming up. Prosecution was on a skeleton staff, unable to even pursue trial, now has a full slate of prosecutors. And the courts have been catching up and issuing orders to bring cases back up to speed. So I think that what you're seeing out in the world is the result of years of short staffing and backlogs that led to not just, day-to-day enforcement not happening very effectively, but also creating a perception that laws weren't enforced. And so we are coming back from that now, but with all pieces of the system, working or on their way to working really well. We are optimistic that everyone should be optimistic that things will actually change.
So the answer ultimately, and it's one I've been propounding out there, is that all of the parts are finally getting back to baseline and starting to function. So you should see some form of change. I think that enforcement is pretty important. You previously stated along the lines of, if there's not a penalty, then is it really a law? And I've been in the dog waste world trying to get our friends at Animal Care and Control to do 1 day a month in a series of parks where they go out and ticket people for not picking up dog waste, because that will create a sea change of behavior in the parks, because people will know I might get in trouble. And so seeing some form of enforcement is probably important. And I'll just end on a philosophical note before I hand it off to Aaron, that the conversation at my community council last night on this topic really surrounded the social contract being broken. That things aren't actually working how they're supposed to work. And so it does sound promising that we're going to be holding our end of that deal up. So, Aaron?
I think I'm actually struggling a little bit to formulate my thoughts, and I think maybe that's because they're running on 2 parallel tracks. So I'm going to try to do both. But I think what would be helpful, so we sort of started down the road of like, what does enforcement actually look like? But I'd like to complete that loop. So we talked about what would likely happen. AFD responds, they put out the fire. If it's determined that there's some kind of criminal behavior based on this new code, the police would be notified. The police would show up and issue citations. And in the event that there was public intoxication, there would be the potential of arrest. And then what? Then is the person who, I guess this is a procedural question. Is the person who was issued the citation then expected to appear in court? And in the event that this person has no address, how would they be notified? Like procedurally, how does someone without an address, how is someone without an address disincentivized from continuing behavior if there is no functional way to like have them take accountability? And how many misdemeanors do you get before it's, like game over? Like there is actually an immediate consequence, or is that a thing? Or is it, and I'm thinking, and so there's track 1, okay? Track 2 is public perception. Right. So if we have laws on the books that say that people will be held accountable for fires, but the process for holding them accountable has so many gaps that the folks who maybe most need to be held accountable for open burns cannot functionally be held accountable. But the people who are going to be held accountable are the theoretical teenagers on the beach out at Point Warrentoff. I think I'm concerned about the perception by the public that we did this thing, we said things were going to change, and then nothing functionally changed because there's been a fire at the encampment near my home for the last 3 days in a row and nothing's happening. Right? I think there's a real danger with that to say that we're going to change something functionally, but then the evidence of that change is not apparent. And I don't have a great solution for that at all, but I would love to hear the wisdom and experience of the 5 people sitting across from me about how this gets addressed.
Through the chair. So if the alleged defendant is cited and released there at the campfire, APD gives them a piece of paper that says, here's your court date, time, place. Between that citation and the actual court date, APD and the prosecutor's office work to pull all the evidence in or start that process. If they show up at the court hearing, they may or may not be appointed counsel, or they can hire their own or represent themselves, and the whole process gets started. So if they fail to appear, then a warrant is issued, and we may bring them around through a warrant, which then gets them into jail, and then they get arraigned on their charges, and additional court dates are set. So that's that process. If they're arrested at the scene, then they'll be arraigned, if we keep the case, the next day or the day after, depending on timing. So either way, they're going to have a court appearance. If they refuse or fail to show up when they're supposed to, then there's a warrant issued for them. So regardless of their address, I guess I should add to that. It doesn't matter what their address is. It's because they have that paper, and the police get their personal identifiers, so we know who they are.
And I think your question actually emphasizes why this is being brought forward, because right now we have civil enforcement mechanisms, which are more like, oh, we'll write you a ticket, or write a citation, give you a fine. It may, not mean a whole lot to most people. But the criminal process does require people to show up, and it does hold them accountable. And if you fail to show up in court, and you're supposed to show up in court, you end up in, with a warrant out for your arrest, and you end up in jail. So there are actual, consequences to not participating in the process.
That's helpful. Thank you.
Zach.
Yeah, thanks. Question to Chief Shiragi. Do you have any sense of how many fires AFT typically, especially fires in public places where it would be prohibited, if the statute were in effect, how many of those you guys have been going around to and putting out in any given summer?
We do, Member Johnson through the chair. Yeah, yes, we do know. I don't know what the numbers are off the top of my head, but we do track that. It's a not an insignificant number.
Yeah, so with it too, also how often do you find you're going back to the same place, right? I guess I'm curious, do you go to a camp, you put out the fire, sort of say, please don't do that, it's dangerous, walk away, and then the next day or even a little bit later, the same people are starting the same fires because there haven't really been a lot of consequences. Is that been part of the experience of the firefighters dealing with this?
I don't exactly know, but I strongly suspect that does occur. Brian, do you have a? Yeah. It probably happens where we're going to the same location over and over again.
Yeah, and I can imagine there may be times as well where APD contacts people, but generally, if something's not illegal, then then the law enforcement officers have limited tools to try and discourage that behavior, right? So even if it doesn't come to an actual enforcement action, I think having at least the ability to say this is in fact illegal and doing so can have consequences, as opposed to what I could feel like in the current realm, sort of going out there and saying please don't do it because we don't like it. So this seal feels like a useful tool, however we choose to deploy it.
Okay, so I had myself thinking, but you haven't spoken yet, so I'll let you go first.
So I have in my notes, I heard somewhere, and I'm just wondering if this sounds about right. I think in 2023, there was over 600 responses, and in 2024, over 400 to these type of unauthorized fires. But I don't know if that's correct. I actually sent you an email earlier asking about that. And then I guess my other question, so I guess I just want to know if that sounds right to you. And then my other question is, do you know the cost of a typical response, just like an average cost? Like if you have 400 responses to these fires, in a year, how how much does it cost the fire department, each time? Or how much does it cost the municipality each time that we are responding to that?
Yes, thank you, through the chair. Those numbers sound about correct. It's important to acknowledge that lots of different fires can be categorized as outdoor fires or vegetation fires, and they aren't necessarily all in homeless encampments or things like that. They might be homeowners who are doing unauthorized burning. It can be undetermined, but we do go to fires in camps quite a bit. There are different ways to calculate the cost of a response. We do have in municipal code fee schedule for responding out of our service area, for example, what we would charge a homeowner who lives outside the service area up Eagle River Valley Road. I think it would cost several $1,000s for us to go to a fire up there. For our annual SEMT calculation of the cost of a call, that's a higher number because it takes in the totality of training and infrastructure and every other component of the department. Comes to about $4,500 per response. So it just depends on how you want to measure that, but similar to my previous answer, it's not an insignificant amount.
Go ahead.
Through the chair, I just want to make it clear that the mayor's goal in this ordinance is not, we're not specifically directing this at people who are unsheltered. So what we're seeking is across the whole municipality that during fire season, all of us understand that having fires that you're not directly controlling is putting everyone else in peril. So it may be that some people, are in that situation more frequently than others, but I just want it to be very clear that the purpose of this is around creating that kind of extra safety during burn season and then allowing the fire department and others to make that very clear across the community that that's the expectation. So that we're all sharing that with our teenagers and our, friends who like to burn grass and maybe like our elderly parents who might still be doing that. So that's the import here. And I just want that to be really clear.
So I have myself in the queue, but I will say on more than one occasion in the last 24 months, I've attended personally a bonfire on a beach in the municipality. So I'm not pointing to someone else, my friend. This is me we're talking about. But there's a practical reality that we're talking about here as well, beyond the general application. And it's the specific application of people who are in public spaces that are highly dangerous and kind of long habits of burning things. So I want to drill back into what happens when an incident arises that this needs to be applied to. And I still don't quite grasp how it's going to work. So for newer members, you'll hear me say this almost every time we have a conversation between the fire and the police. There's a long history in the United States, probably in the world, that your fire service does not do law enforcement. And that's for a number of very important reasons. The first of which is our fire service is the only branch of government allowed to enter your home without a warrant. They go where angels fear to tread without Kevlar. And we want to protect that relationship in the community. So what does it look like then when the fire department shows up to a fire in a public park and the time between when the fire department makes the determination that this is a risk and it might be subject to this section of code to when the police shows up to when some action could happen? That's a universe of time probably where the fire gets put out and people scatter. You're not detaining people. I'm pointing to the fire chief. And so how is this supposed to actually work from a real world perspective? So it gets back to your question, Aaron, at the beginning, but are we thinking that we would deploy a cruiser on fire calls when they're in certain places to capture that? Because there's only one way to be there. And do the firefighters serve as witnesses in that process, right? Because ultimately, isn't you being a witness the same as you being the person who's arresting. Anyhow, those are questions. How is it supposed to actually work? Nuts and bolts, right in that narrow moment.
Mr. Chair, as I mentioned earlier, we have already started co-dispatching to these calls. First of all, that happens from time to time throughout the course of time anyway. So that's not something totally new, but definitely trying to free up police cars earlier, understanding that we can't have fire personnel be at a location for 45 minutes trying to get people to stick around without going outside of what they're called to do. So in other words, they're not using force. They're trying to convince people to stay, which, as you all can imagine, doesn't work well at all. So dispatching us a patrol car at the same time with the fire department is the goal. And generally speaking, in terms of are they witnesses or are they not witnesses, if you have a member of the fire department that is the only one that saw that person light a fire or that person that met some evidentiary value that was the only link to us arresting someone, the officers are going to put their name in the police report because otherwise there's no case. Generally speaking, the people on scene have a little bit more valuable information because the fire department is showing up late to the fire, and people that are there and around the fire have a little bit more of they were here for 30 minutes, 40 minutes, hours. So they have actually better information or better witnesses. So that's how that portion would work.
So I think from a policy perspective, like on the ground policy where the rubber meets the road, some care and attention needs to be spent on setting up rules of engagement to protect the fire department's role, to make sure that someone is there to see with their own eyes and be the person who captures that evidence. Because again, that delta in time will be the issue. And I know this can't be every call, and I know you do it sometimes. Every time there's a fire in my neighborhood, police are managing traffic around it. And so I agree with you that plenty of evidence to say that this is the way that it happens already in a lot of cases. But in these cases, it's probably really important, especially at first, to have a really coordinated approach to landing the plane. So anyone else? Any closing thoughts? We have 5 minutes. Dennis.
Through the chair, just to build on what you and the chief were discussing on this build of the evidence, I would point out that there have been a number of circumstances where we have a neighbor or some other witness that we can subpoena or they can volunteer to come in. They may have video, which the police can cooperate and load into our system. If the police come on scene and witness something, we wouldn't necessarily have to call the fire department personnel if the police can testify to the same evidence. So we wouldn't waste our time bringing in more people than necessary to prove the point. So we do have some ability to work with the evidence given to us and avoid calling in fire department resources if we don't need to make the case.
Yeah, I think though that work is on the front end long before it enters the hollowed halls of the second floor. It's out in the dirt to make sure that that procedure is really built to achieve that goal of limiting exposure of the fire team to being the enforcement function. And so I'm sure that's doable. Cameron?
If this does pass, how will the public become aware of it? What's the plan to make sure that people are now aware that this is a new regulation, a new law? Is there anything just to make sure that those that may have done something before that now is going to be illegal or is going to be prosecuted in a different way? Is there any kind of public awareness plan?
Yeah, thank you, through the chair. We've had some very preliminary conversation about this. So there's some really obvious things like in our parks, we already have signage and rules and we're able to put out more information that way. And so I think just between the different departments that would be involved, we would be putting out some public education and getting the word out.
And Chief Shruggy, I would imagine with all the fire sort of awareness work that the fire department is doing in terms of making people aware of all of the dangers, that sort of thing. There may be some logical placement of this within that communication. Would you agree? Or does that fit within the communication campaigns you're already doing?
Yes, through the chair, member Presfordia, certainly, we would add that to our messaging. If or when this ordinance passes or takes effect. One of the first things that we will do also is within the framework of the proposed ordinance, we would take an immediate look at what particular areas present the most risk of fire escapement, and we would work to identify those areas as prohibited areas for burning.
So in my community council work the last week or so, there have been two questions that continue to come up on the turning the tide conversation. And it's along the lines of are you actually going to do it? Well, three questions. Where do people go if they're being abated? And the third piece is how do we know it's working? How are we going to demonstrate it to the public? And when should they be asking, is it working? Or it's making their assumptions that it's working or not. And so it's kind of a little obtuse to this ordinance, but there is like a layer of conversation in the community about how are we going to measure the change over time and demonstrate it. And so I think there is an angle of that to this, but I hope that the folks are really starting to think about it. I think you are. I talked to the mayor about it, key performance indicators and other measures. And so it's going to make it a lot easier to continue to get out there and be the advocates when we are able to point to success. So I wish you success. And with that, we'll be adjourned. We have another work session in 10 minutes. We'll be back.